Hello viewers, I am Dr. Sharanjeet. In today's lecture, we shall be discussing capital punishment in India. But before I discuss capital punishment in India, I would like to ask all of you one question. Do you agree with the statement given by Charles Dickens when he said, "Law grinds the poor, the rich rides on them"? As discussed in the previous part, death penalty has been prevalent in India since very ancient times and is a part of the penological aspect of the criminal justice policy. For understanding the aspect governing capital punishment, it is important to throw some light on the legislative framework in India. The Constitution of India has under Chapter 3 enumerated certain fundamental guarantees assured even to an accused person. The relevant provisions are discussed. The first is right to equality. Article 14 of the Constitution of India provides equality before law and equal protection of law. Similarly, Article 7 of the Universal Declaration of Human Rights provides that all are equal before the law and are entitled without any discrimination to equal protection of the law. Constitutional guarantee of the right against ex post facto laws. Article 20, Clause 1 of the Constitution of India states, "No person shall be convicted of any offence except for violation of a law in force at the time of the commission of the act, charged as an offence, nor be subjected to any greater penalty than that which might have been inflicted under the law in force at the time of the commission of an offence." This provision is almost identical to Article 11(2) of the Universal Declaration of Human Rights, right of an accused against double jeopardy. Article 20, Clause 2 of the Constitution of India guarantees that no person shall be prosecuted and punished for the same offence more than once. It is based on the celebrated maxim "Nino bis debet puneri pro uno delicis", which means that no one ought to be twice punished for one offence. The right of the accused against self-incrimination. Article 20, Clause 3 of the Constitution of India states that no person accused of any offence shall be compelled to be a witness against himself. The Constitution and the courts protect the right of silence of the accused both during interrogation and the trial. Article 14, Clause 3(g) of the ICCPR also states, "No person is to be compelled to testify against himself or to confess his guilt." Then we have the right to life and personal liberty. Article 21 states, "No person shall be deprived of his life or personal liberty except according to the procedure established by law." This right has been given paramount position by our courts. Most fundamental of all human rights that man can aspire for is the right to life. Denial of this basic right means denial of all other rights, because none of the other rights would have any utility and existence without it. So, this right has been stressed by international, regional and national documents. In several cases before the Indian courts, it was stressed that capital punishment is in direct violation of the right to life. However, the judiciary has observed that death penalty is itself not unconstitutional and can be invoked in the rarest of rare cases. The precious right guaranteed by Article 21 cannot be denied to convicts, under trials, detainees and other prisoners in custody except according to the procedure established by law, by placing such reasonable restrictions as are permitted by law. It cannot be said that a person sheds off his fundamental right to life the moment a policeman arrests him, nor can it be said that the right to life of a citizen can be put to abeyance on his arrest. Any form of torture or cruel, inhuman or degrading treatment would fall within the inhibition of Article 21, whether it occurs during investigation, interrogation or otherwise. Moving on to the next constitutional right, that is right to legal representation, Article 22 guarantees to every arrested person the right to consult or be defended by a legal practitioner of his or her choice. In this regard, it is important to make a reference to the important case of Nandini Satpathy versus P.L. Dani, wherein the Supreme Court rightly observed that the right to consult a legal practitioner was the best promotion of the right against self-incrimination. Further, in D.K. Basu versus State of West Bengal, the Supreme Court gave procedural safeguards in case of arrests and detention of the accused. The Apex Court gave guidelines and were incorporated by a subsequent amendment of 2008 in the Code of Criminal Procedure. The next constitutional right is the right of appeal to the Supreme Court. Appeal to the Supreme Court with regard to death penalty can be made under Articles 132, 134 and 136 of the Constitution. Appeal under Article 134 shall lie under the following circumstances. First, when the High Court reverses an order of acquittal by the trial court and imposes a death sentence. Secondly, when the High Court withdraws a trial from a lower court, conducts the trial before itself and sentences the accused to death. Thirdly, when the High Court certifies that the case is fit for appeal to the Supreme Court of India, then we will discuss the pardoning powers in the constitutional framework. Article 72 and Article 161 of the Constitution deals with the pardoning power of the governor of a state and president of the country. It is to be noted that after the death sentence has been confirmed either by the High Court or the Supreme Court, then the convict can file a request for pardon or mercy petition either with the governor of the state under Article 161 or the President of India under Article 72. Now we move on to the next limb of our lecture, that is the Indian Penal Code 1860. Under the IPC 1860, death sentence has been incorporated as an alternative form of punishment for serious offences enumerated in the following sections. Section 121, waging war against the government of India. Section 132, abatement of mutiny when it is actually committed. Section 194, giving or fabricating false evidence whereby an innocent person suffers death. Section 195A, threatening any person to give false evidence resulting in conviction and death of an innocent person. Section 302, murder. Section 305, abatement of suicide of a minor, insane and intoxicated person. Section 307, attempt to murder by life convict if hurt is caused. Section 364A, kidnapping for ransom. Section 376A, rape causing death or resulting in persistent vegetative state. Section 376E, second or subsequent offence punished under sections 376, 376A or 376AB or 376D or section 376DA or 376DB. Section 396, dacoity with murder. With reference to the IPC, death penalty can be studied with reference to the homicide and non-homicide offences. Question often arises whether death penalty is an appropriate form of punishment for non-homicidal offences. In this regard, the judiciary has been vested with wide discretionary powers in deciding whether to award life imprisonment or capital punishment. In a recent judgment of Vikram Singh and another versus Union of India and others, the Supreme Court has upheld the constitutional validity of section 364A IPC for the sentence of death when kidnapping is for ransom. Similarly, in the Shakti Mills gang rape case, the accused were sentenced to death for the gang rape of a woman. This case deals with the gruesome gang rape of a 22-year-old photojournalist in Mumbai's Shakti Mills on 22nd August 2013 by 5 men including a minor. The women had gone to the Shakti Mills with a male colleague for the purpose of an assignment when she was raped and her male colleague was tied with belts. The young woman was not only gang raped, but her pictures of the sexual assault were also clicked, and she was threatened that if she complained the matter to the police, her photographs would be posted on social networking sites. After the incident, she reported the entire matter to the police, and within a few days, an 18-year-old girl working in a call center also made a police complaint of being gang raped at the same place. Investigation commenced and the accused persons were arrested. On 20th March 2014, the Mumbai Sessions Court convicted all 5 adults in both the rape cases. On 4th of April 2014, the court awarded death penalty to the 3 repeat offenders in the photojournalist rape case. For the other 2 accused, one was given life imprisonment and the other turned a prover in the case. 2 minors, one in each case, were tried by the Juvenile Justice Board. They were convicted on 15th of July 2015 and sentenced to 3 years in a Nasik Borstal school. Coming to the procedural aspect of death penalty, we shall be reflecting upon the Code of Criminal Procedure 1973. In the Criminal Procedure Code, certain provisions have been incorporated to ensure that death penalty is used only where it is actually needed. For instance, Section 366, sentence of death is to be submitted by a court of session for confirmation to the High Court. Section 367, power to require further inquiry to be made or additional evidence to be taken. Section 368, power of High Court to confirm sentence or annul the conviction. Section 369, confirmation or new sentence to be signed by 2 judges. Section 370, procedure in case of difference of opinion. Section 415, postponement of execution of sentence of death in case of appeal to the Supreme Court of India. The other legislations which provide for death penalty are, apart from the IPC 1860 and the CRPC, we have 17 other laws in which a provision for death penalty has been inserted with different legislative rationales. The Army Act 1950, the Air Force Act 1950, the Navy Act 1957, the Arms Act 1959, the Geneva Convention Act 1960, the Petroleum and Minerals Pipelines Acquisition of Right of Use in Land Act 1962, the Unlawful Activities Prevention Act 1967, the Border Security Force Act 1968, the Coast Guard Act 1978, the Narcotic Drugs and Psychotropic Substances Act 1985, the Commission of Sati Prevention Act 1987, the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act 1989, the Indo-Tibetan Border Police Force Act 1992, the Delhi Metro Railway Operation and Maintenance Act of 2002, the Suppression of Unlawful Acts against Safety of Maritime Navigation and Fixed Platforms on Continental Shelf Act 2002, the Assam Rifles Act 2006, the Sahastra Seema Bal Act 2007. So, these are the 17 central legislations in which death penalty has also been incorporated. Listeners, now we shall be talking about invocation of death penalty in terrorism offences. Specific laws have been enacted to deal with terrorism, and these laws have incorporated capital punishment as a form of punishment. The anti-terror laws in India provide for death penalty in a number of cases. In Devinder Pal Singh versus State of NCT Delhi and another, dismissing the accused's appeal and confirming the death sentence, the Supreme Court held that terrorists who are sometimes described as death merchants have no respect for human life. Innocent persons lose their lives because of mindless killing by them. Any compassion for such persons would frustrate the purpose of enactment of Terrorist and Disruptive Activities Act and would amount to misplaced and unwarranted sympathy. Now, moving on to the next part of the discussion, that is with regard to narco trafficking and death penalty. Geographically, India is sandwiched between two major sources of supply of illicit drugs, the Golden Crescent, that is Afghanistan, Iran and Pakistan, and the Golden Triangle, Burma, Thailand and Laos. It is important to note that the illegal trading in narcotics has become the foundation of organized crime. All kinds of illegal activities like extortion, flesh trade, smuggling, trafficking in arms, bottlenegging, dealing in real estate, foreign exchange rackets, import-export transactions, films, stock market manipulations, and not to forget money laundering are effectively controlled by the narco traders. To deal with the menace of drug peddling, the Parliament enacted the Narcotic Drugs and Psychotropic Substances Act 1985 with stringent provisions. Section 31A of this law provides for death penalty in repeat conviction for certain offences under the Act involving the trafficking of commercial quantity of any narcotic drug or psychotropic substance. Moving on to the Law Commission of India, in the 35th Law Commission of India's report on the mode of execution of death sentence, it was observed, having regard to the conditions in India, to the variety of social upbringing of its inhabitants, to the disparity in the level of morality and education in the country, to the vastness of the area, to the diversity of its population, and to the paramount need for maintaining law and order in the country at the present juncture, India cannot risk the experiment of the abolition of capital punishment. Another important aspect with regard to invocation of death penalty is age of the offender. Age is often considered as a mitigating factor while awarding death sentence. In the landmark case of Bachchan Singh versus State of Punjab, it was held that if an accused is young or old, he shall not be sentenced to death. In terms of young offenders, the judiciary often considers it to be a mitigating circumstance, as it if felt that reformation is possible for such delinquents. It is also assumed that young people often lack the maturity to judge and understand the nature, consequences and seriousness of the wrong committed by them, and thus punishing them with death is too harsh and not in tune with the present human rights standards. The Juvenile Justice Act prior to 2015 also provided that a juvenile cannot be sentenced to death or life imprisonment and can be at the maximum sent to the reformative home for a maximum period of 3 years. To conclude, as discussed above, death penalty is a part of the substantive criminal law as well as specific central legislations. Death penalty has been incorporated in different legislations with different legislative intents. For instance, under section 31A of the Narcotic Drugs and Psychotropic Substances Act 1985, with the object of deterring drug peddlers, in the Unlawful Activities Prevention Act 1967, object is to punish terrorists and their masterminds. As law, has to balance the conflicting interests in the society, it becomes integral to the criminal justice administration that the judiciary exercises its discretion to award capital punishment by in-depth evolution of the case. In the end, to quote Florence Ellen Wood Ellen, the attainment of justice is the highest human endeavor. With this, I bring an end to the lecture. Thank you very much.